Is there an application in the matter of children?
Yes, Miss Madison.
May it please your lordships, in this matter I represent the appellant mother, along with my learned friend Miss Gord-Handus.
Yes.
As you can see, Mr Davies, my learned friend Mr Davies represents the respondent local authority.
Before we go any further, we've had an application from a member of the press to have copies of the skeleton arguments. The application only came to us as judges first thing this morning. The normal course is, if the person was in the building, to hand them copies, and the rules require parties to bring 2 hard copies of their skeletons, and in a family case, redacted copies. But we didn't trouble all of you in the hour or so before coming into court to provide that, partly because the individual is watching on the live stream and is not in the building anyway. So what we propose to do is to direct that the parties provide anonymised versions of the skeleton arguments, so that'll be 2 on your side, the original one and the later one, and yours, Mr Davis, in 24 hours' time for us to send to the journalist and read any other journalist who would like a copy.
Yes, my lord.
Thank you. Yes.
My lord, insofar as this appeal is concerned, this appeal is not a collateral attack on the trial judge. It is not a submission that Her Honour Judge Gillespie acted irrationally or that she failed to consider the evidence before her. The appeal rests on something narrower but more fundamental: whether the decision was rendered unjust by a serious procedural irregularity unknown to the trial judge at the time, namely the instruction and reliance upon the psychological expert evidence, which was not lawfully competent for the remit the court had authorised as necessary. With respect, the local authority's skeleton does not truly engage with that. It repeatedly answers a different case. It says that the judge had a wide canvas. It says that there were factual findings. It says that care orders were inevitable. But that is not, respectfully, the legal question that this court is required to answer. The legal question is whether the integrity of the evaluative process, risk, insight, capacity to change, and proportionality.
Sorry, you have to take it more. Sorry, but whether the integrity of the evaluative process.
My lord, yes. Risk, insight, capacity to change, and proportionality can safely stand when the court's necessary expert lens was defective. The respondent's position, reduced to its essence, is even if Mr Flatman is removed from the picture, the care orders can stand. That submission, however, risks misunderstanding the structure of the judgment. This was not a case where the court made freestanding factual findings and then only incidentally referred to a psychologist. The court made evaluative conclusions about the mother's insight, honesty, ability to work with professionals, and capacity to protect, conclusions that were central to the proportionality of permanent separation of her children.
Yeah. So in saying that was the legal test, what sits behind that, you're saying, is whether the integrity of the evaluative process can safely stand if the expertise is compromised. So what's the legal principle beneath that, upon which that rests?
The legal principle, my lords, and of course you have seen that a number of remedies have been put before you on the part of both the respondent and the appellant, is that we say that, and whilst we accept that the local authority says that the proper remedy is a discharge application, and if necessary to reopen findings.
That's to do with remedy. I mean, your case in your skeleton is pitched at a high level. You say that the expert acted unlawfully, and you're saying this is a legal test that we have to apply. So asking what's the legal principle that you say has been breached here that justifies your appeal being allowed.
We obviously rely on Article 6, the right to a fair trial.
What was unfair about the trial?
Forgive me, my lord.
What was unfair about the trial?
In cases such as these, where an expert is deemed to be necessary, and particularly where at the heart of this appeal is the fact that the family court is more restrictive in allowing expert instruction, so that is on the basis that it is necessary, and indeed regulating when cross-examination can take place, particularly more so than in other jurisdictions. Experts must therefore be of the necessary expertise, and they must be at the highest standard of that expertise, because in line with Article 6 principles, failing that high standard, there would be a terrible injustice in the form of a parent losing their children as a consequence. And in our circumscribed system, we say that experts must be who they say that they are.
But did Mr. Flatman say that he was something that he wasn't?
My lord, there are certain deficiencies insofar as how Mr. Flatman has indicated, certainly within this case, what the level of his expertise was, we say respectfully. If one considers the experience that he sets out.
This is in his CV, is it?
No, it's not in his CV, my lord, but I will take you to that because I have been provided now with his CV. But if we could take a look at his report, and this is page 194 of the appeal bundle, the main appeal bundle. At page 194 of the appeal bundle is his signature. There is no declaration insofar as him using his protected title that he is an educational psychologist. He simply refers to himself as a chartered psychologist. At pages 196 to 197, under the heading of qualifications and experience.
Yeah, that's his CV.
Yes.
Yeah.
Was there anything untrue in that?
No, my lord, there's nothing that was necessarily untrue, except that at page 197, in the second paragraph.
You're entitled to say that's incomplete,
Yes.
but it's not untrue.
No. But in circumstances where the, as was set out in the tribunal, outcome, and again that is at page 24 of the supplemental bundle, and that's paragraph 65. The BPS guidance is quoted as saying that all psychologists that are eligible to do so.
Sorry, give me the page again.
That's page 24.
Yeah.
All psychologists that are eligible to do so should use their protected title. And we say that in this case, Mr. Flatman did not use his protected title as being an educational psychologist.
That's against the guidance.
Yes.
Right.
I mean, what went wrong in the tribunal case, as I understand it, is that Mr. Flatman accepted instructions as a clinical psychologist, which was a protected title to which he wasn't entitled. But in this case, he was simply instructed by name as a psychologist, not a clinical psychologist.
Yes, that is true. However, it is clear from the letter of instruction that the terms of the instruction was essentially to perform a clinical psychological assessment. And what we see from Mr. Flatman's report is that he performs a number of psychometric tests for which he was not qualified to undertake. And that is also something that appears within the tribunal decision. So, for example, the panel determined that on the balance of probabilities between the 30th of April 2018 and the 13th of June 2018, Mr. Flatman conducted psychometric tests during his psychological assessment, and that he used the MCMI-3 psychometric test in the psychological assessment of that individual, and that was taken to have been Mr. Flatman going well outside his remit. And in our case, at page 125 of the main bundle, he performed the MCMI-3 assessment, and at page 126, he indicated that the mother had produced an invalid score on that assessment due to invalid disclosure. And he draws upon that test, and the reference for that is at 174, to suggest that the probability for the invalid assessment is her tendency for minimising and avoiding. He also performed, and this is at page 125, the MCMI-4 test. Again, this is a psychological assessment.
Which paragraph on 125? Maybe the electronic number is not the same as...
The
paragraph numbers are quite precisely shown.
3.5.15?
3 point, yes,
Yeah, that's 124.
yes, forgive me.
Okay.
And my lords, 3.6.1, the MCMI-3.
Yeah. So you say he wasn't qualified to apply the WAIS-4 test.
In conjunction with, just forgive me, my lord, for a moment. My recollection is that the Wechsler assessment tool was deemed by the tribunal to be something that Mr. Flatman could carry
Yes.
out. However, the MCMI-3,
Yes, the MCMI is the one that you're
it is,
concerned with.
it is.
One way of doing this, which might be helpful, it certainly would be to me, is for us to look at some stage at the questions that were asked in the letter of instruction, and for you to identify questions that you say were improperly asked, in the sense that they were asking Mr. Flatman to stray, and you can then supplement that by reference to his report if you say he strayed in any other way. But would that at some stage be a useful exercise?
Yes, it would, my lord, and I'm happy to do that now. if your lordships have the draft letter of instruction to hand,
I think it's the very, very back of the bundle, isn't it?
the as I understand it, the draft letter of instruction was sent separately.
Well, if others have it, I have a page which is useful at page 385. It came in a later.
Mine stops at 37.
In that case, it's a separate document.
Yes, I've got the instruction letter loose.
Essentially, then, if you can look at this draft letter of instruction.
Can we just wait to see that
Oh.
we've all
Yes.
got it?
Yes, I've got it. It's not numbered. But, yeah.
We come to a page under 4, under heading 4, and on the following page and the page after that there are no fewer than 26 questions which he then deals with in his report. Clearly you're mostly concerned, I would imagine, with the questions about psychological assessment of the parents, in particular the mother.
Yes.
Do we need to trouble with any of the first 10 questions, which are all about the children, or are those accepted to be within his remit?
The only difficulty, insofar as the assessment of the children are concerned, is that, and again, and forgive me for taking your lordships back to the main bundle, but at page 150 of his report, there are certain tools in which he assesses the children which go beyond.
Well, that's fine. That's an opportunity
Yes.
to help us now as to whether any of, in the first place, whether any of these questions about the children is intrinsically inappropriate because it invites him to stray.
Yes. We would suggest that questions 1, essentially a full psychological assessment of the children individually, 2, their current psychological and emotional health, commenting on whether they appear to suffer from any psychological.
Why followed the drift? Why is there anything wrong with that? I thought that from the learning that we got from the tribunal decision, that Mr. Flatman, as an educational psychologist, was entitled to deal with these questions in relation to individuals up to, in some cases, the age of 25, but certainly the age of 19. So why would a full psychological assessment of the children be outside the remit of a chartered and educational psychologist?
My lord, I take that point. The issue, I suppose, is that there has been an interplay in his psychological assessment of the psychological difficulties with the children as attached to the mother. So insofar as...
Well, the question my lord's asking is whether these questions, 1 to 10, were inappropriate because they were outside the professional remit of an educational psychologist as a chartered psychologist.
I take that point.
So are you accepting that they were proper questions
Yes.
to ask someone
Yes.
of his actual
Yes.
qualification? Yeah.
Yes. Insofar as the mother is concerned, there are obviously 16 questions posed in relation to her. The numbers 1 to 5, we say, fall outside of his remit, and by extension, questions 6 to 16 on the next page.
6 to 16 also fall outside his remit?
Yes,
So that's all of them. 1 to 5 and 6 to 16.
yes.
Right.
So what this boils down to is he shouldn't have been asked to do anything with the mother, or the parents rather.
Yes. essentially that is the argument, because as the BPS guidance demonstrates, there are definitive parameters between what an educational psychologist is permitted to look at and, by extension, what a clinical psychologist is allowed to do.
And do you have to take us to that?
When you say allowed to do, are you going more widely than the regulatory scheme?
No, my lord. Of course, the benefit of the BPS guidance is that it provides helpful parameters for what is permitted by those different disciplines. And what the guidance does is that it explains that educational psychologists are trained to work with children and young people. I will find the reference. But the core training doesn't include working with adults in the way required for clinical assessment. And that includes adult mental health, personality assessment, adult diagnostic issues in the psychological treatment domain. And for your lordships, that appears at, it's set out in the authorities bundle at page 172.
Could you give an internal reference, please? I'm working from a loose copy.
The internal reference is page 23.
So that's the educational psychologist.
And if we were to look at page 173, internal page 24, there are 4 bullet points. And of course, one of the bullet points is in respect of core training does not equip the educational psychologist to offer psychotherapy or other psychological treatments. Of course, he was asked to comment on whether any of the children would benefit from any treatment or therapeutic input in the question 8 of the letter of instruction. And insofar as the remit of clinical psychologists are concerned, that appears at page 171. And we say that it is very clear that the work of the clinical psychologist is by far extremely different to that of the educational psychologist. And that is why a clinical psychologist was clearly best placed to provide the psychological assessment of the mother. We say that the purpose of the clinical psychological assessment in this case required psychometric testing, as you've seen, an assessment as to the mother's insight, her capacity to change, protective capacity, and future risk. And whether or not Mr. Flatman said directly that he was not calling himself clinical, the question is whether he performed a clinical task. And we say that is exactly what he did.
What is it that stops him doing that?
Well, again, as your lordships will have seen from the tribunal, whilst there are certain parameters of recognised professional codes of conduct and ethical frameworks, it is the responsibility of the psychologist to be transparent in relation to their qualifications and registration. And what we find from the tribunal decision was that there was an element of subjectivity on Mr. Flatman's part, who, by virtue of his years of experience, clearly took it upon himself to be of the view that he was sufficiently qualified. Of course, in the tribunal decision, it was clear that he fell outside the remit of his expertise, and that insofar as the tribunal decision was concerned, he was found to have acted outside of his remit. So the difficulty in this particular case is that the court did not know that Mr. Flatman was an educational psychologist. And my lords, you may have seen an application by the local authority to rely upon an email that is described as having been sent to all of the parties at the time that he was instructed. What we say in response to that...
This supplemental bundle 60.
Yes. What we say in response to that is that it is clear from that email that council and social work professionals were aware in 2022 of a live complaint or a regulatory concern in relation to Flatman, yet the mother's legal representatives were not included in that email chain. And there is no evidence that the issue was put transparently before the court for evaluation at the point of instruction. We say that matters because it demonstrates that mother didn't simply sleep on her rights. She did not make a forensic choice not to challenge the expert.
Could we, I hadn't appreciated or picked up when I was looking at these emails, that emails you have to read backwards, aren't they?
Yes, they are.
Right, so if we start at 61.
On the hard copy, it's 60. Dear Jeanette, what are Graham's timescales?
Yes.
Yeah.
So this is counsel for the local authority or counsel for the guardian?
This is counsel, so essentially in this email, counsel for the local authority, counsel for the guardian. The social...
No, who? Mr. Howell. Is that local authority? Or is it guardian?
The guardian.
This is nodding.
Guardian.
Guardian.
Guardian, thank you.
Right.
So, counsel for the guardian very industriously tries to find an expert, asks Mr. Flatman's administrator if he's available, and receives the message with a footer in relation to the tribunal proceedings.
Yes.
Yeah.
Now, and the inquiry was sent only to council and the reply was sent only to council at that stage.
Yes.
Right, then there's a follow-up. Could he travel? And a reply, yes, he can. And armed with that information, council reports back to her instructing solicitor, or is it to the local authorities council?
It's the Local Authorities Council.
Right, so the conversation has now widened out to two council.
Yes.
Where do we go to from there?
And thereafter, there are 2 social workers and a team manager that are copied into the email trail.
But so when we get to AMC and ST, who are they?
They are the local authority solicitors.
Right, so by the time we get to the 8th of March, it's with the local authority solicitors, and then continuing.
It stays with them.
So this must at some stage have been communicated to the legal representatives of the parents in some shape or form.
Our instructions, my lord, and we've tried to make sense of this email because we were not the legal team representing the mother. Our instructions are that the mother's solicitors were not made aware of this email.
Well, I'm separating out whether the whole email trail was forwarded, or whether they were just told Mr. Flatman is available, and we propose him. Local authority are happy. What's your view? There must have been some sort of engagement of that sort, because otherwise Mr. Flatman could have appeared on the scene.
Quite so. We know that Mr. Flatman was obviously instructed to be the expert, but all that I can say to your lordships is that the mother's instructing solicitors at that time were not aware of the...
We're not in a position to, I mean, I'm not seeking to cast doubt on what you say, but we would surely have to see the whole email trail involving everybody before we came to a conclusion of that sort.
Of course.
So
of course
is it practical, because people have got sufficient access, for us to have the whole email trail in relation to the instruction of Mr. Flatman?
I had in fact spoken to my learned friend Mr. Davies, who kindly indicated that the local authority cannot locate an email that was sent to the mother's legal representative.
And you're not in a position, because it's a different firm of solicitors, to go back into the mother's solicitor's inbox, as it were, to find out what they knew.
That's correct.
So do we not have to rest on the basis that it is unclear, because the data is incomplete, whether Mr. Flatman's disclaimer at the end was shared with the parties as it obviously should have been?
I think that would be the fairest approach, my lord.
Thank you.
Can I just clarify a matter? You said the court didn't know that Mr. Flatman was an educational psychologist. And so if we go back to the CV, which we've got in the hard copy bundle at 197, are you there?
Just one moment, my lord. Yes, I have it.
Right. So I think that the first paragraph shows that his original qualifications were educational psychology. But then I think there are grounds for your expression of concern moving further down, because in the middle of the page, I have extensive experience and act as an expert in child, adult, and family-related issues in clinical and legal context, I continue in private practice assessing and treating a wide range of psychological issues in children, adults and families.
Yes.
And so that's the foundation for he didn't say, I'm just an educational psychologist, and that's the limitation of my registration, which is the point my Lord referred to some time ago. I'm registered with the HCPC, but it doesn't narrow that down. He's making a positive assertion that he's got a clinical practice treating adults and families as well as children.
Yes, my lord. And as no doubt your lordships will have seen from the tribunal's decision and the way in which Mr. Flatman gave his evidence, it was clear from the way in which he gave his evidence that he felt that he was suitably qualified by virtue of his experience, even though, of course, the tribunal found against him on the basis that has already been set out. It's also clear at page 114 of the main bundle at paragraph 3.11.
311.
Yes. That he indicates that medical records are reviewed from the perspective of my expertise as a psychologist.
What page?
115. Yes.
At the bottom of the page.
Can we take note of the fact that it seems that the standard procedure for the appointment of an expert was not fully followed in this case? Normally, as I understand it, the parties wanting an expert to be instructed will file an application. That will exhibit the details of the expert or experts that they propose to instruct. It will include the CV of each of the experts that is proposed, and the court will then have its opportunity to vet that and to appoint somebody if they think it's necessary. Now, I can't remember whether there was a formal written application to the court in this case for an appointment, or whether it was something that came up at an early stage. Probably it simply was dealt with orally at the earliest hearing. But leaving that aside for a moment, it seems as if the practice that was followed in this case was for the judge to okay the appointment in principle and leave the parties to find somebody in practice. Is that your understanding of the position?
Yes, that is my understanding. There was no formal application.
And if there had been, and Mr. Flatman had produced the CV that we have at page 197, the court wouldn't have been on alert to the fact that he was just an educational psychologist in terms of his registration.
No.
But the fact that the HCPC scheme governs the protected titles is part of the landscape, but that doesn't prevent the court instructing anybody if they consider they have sufficient expertise. And whether he was acting outside his authorization or not, he was saying, look, I've done hundreds of these cases, and this is what I do. So, in a sense, he had got expertise through experience, even though he wasn't formally qualified to do that. And there was no, certainly at that time, no embargo on the court instructing anybody who held themselves out to be a psychologist. And that's what Re-C was about.
Yes. And
So why is, I can understand what you say about the CV and the authorization, how he was acting outside it, overreaching himself. Why does that, as night follows day, mean that he was acting unlawfully, and B, that the process before the judge was flawed to the extent that you say it is, or was?
in addition to the reference that my lord has also referred to, there is the reference in his qualifications and experience at page 196, where he says that he has extensive experience and acts as an expert in child, adult and family-related issues in clinical...
That's what I read out a short time ago.
Yes, it's... yes.
Yes, so he's saying, I'm an expert. It turns out he's not got a registered qualification to be an expert in adults, but he's saying I'm an expert. And was the court prevented, if the court had known the extent of his registration, was the court prevented in saying, well, nevertheless, we think he's a good person? We've had him in previous cases. We'll instruct him in this case.
It's the counterfactual question that I posed in our skeleton argument, which was, I suppose, my lord, if counsel on day one of the final hearing had discovered that he was in fact an educational psychologist and said to the court, we've made a mistake here. This is an educational psychologist who should not have carried out psychometric testing, which also takes into the evaluative process of risk, future risk and concern. Then we say that the court, given that the court is prescribed by Part 25 and that an expert is necessary for the resolution of the case, it would mean that the court would inevitably, we say, have had to have adjourned the case because this expert was not the right expert to evaluate the mother's psychological profile.
Ms. Madison, is it as simple as that? Going back to the letter of instruction, you've effectively conceded that the questions in relation to the children are okay, but none of the questions in relation to the parents are okay. Surely that's really too black and white, isn't it? That these were three children who each in their own way had very serious psychological and emotional difficulties, whether as a result of their parenting or for some other reason, or both. That an educational psychologist, as the later guidance tells us, is somebody who is qualified to deal with issues of that kind. And one surely can't treat the children and their carers, parents, as just being in sealed rooms from each other. Surely if you're asked to decide, you're asked to advise about the educational psychological difficulties of children, that has to be done in some meaningful context. So I quite appreciate, speaking for myself, agree with your submission that he wasn't apparently entitled to carry out the Millen test. But that, as it happens, went nowhere or almost nowhere anyhow. But surely he was entitled to express a view about the children's psychological and developmental state, and express views about how that got there, and what was to be done about it. I appreciate that still leaves you with some ground for complaint, but it's not right, is it, simply to say you can talk about children but don't talk about the parents. You can talk about parents, don't talk about the children. That's not how psychology works.
Yes, I take that point, my lord. The problem with these types of assessment is that there is a straying into the other areas.
Yes, they bleed into each other.
Yes.
I appreciate that, but that's why I at the moment, I'm not quite clear about your submission that counterfactually, if this had been raised with the judge who made the original order, and that judge had to engage with whether Mr. Flatman was or wasn't the right person, they would immediately have said, well, obviously he isn't, because the judge might have pruned some of the questions, but surely they could perfectly well have said, this is a a person who has lots of experience in this area and a great deal of qualification.
But the difficulty with that, I suppose, my lord, is that when a psychologist is being asked to look at adult diagnosis, capacity for change, in circumstances where Her Honour Judge Gillespie not only was looking at the 6 factual findings, but also whether or not it was proportionate to sanction a long-term separation by way of foster care.
But he wasn't the only witness about that.
He wasn't, but it's clear from, we would say, in Her Honour Judge Gillespie's judgment, that insofar as looking at the welfare considerations of long-term separation, that she relied upon Mr. Flatman's assessment that this mother was still in denial because of how he had conducted the assessments and because he strayed into areas insofar as the psychological assessment of the mother was concerned.
Well, insight, for example. Insight is not an area that you need to be an expert, is it?
No, but the capacity for change within the children's timescales, safeguarding risk, relational attachment foundations, and formulations,
Well,
we say.
Unpick those and take, for example, attachment. Is he not entitled to express an expert opinion about the children's attachment to the parents? I'm sure I have the language wrong, but the attachment as between the children and each parent.
He could talk about the attachment of the children. I'm not sure that he could talk about the attachment of the mother towards the children, because that would the attachment style, or, for example, one of the questions that he was asked was whether or not the mother had a personality disorder, and that would affect, of course, whether or not that affected the attachment towards the children. So that's where, as your lordship has commented, one bleeds into the other. That's the difficulty, is that this educational psychologist was being asked to consider this mother's capacity to
But
change.
he didn't offer a diagnosis about personality disorder.
No, he didn't.
No.
But he did comment on the mother's attachment style with the children.
Can I ask this, going back again to the appointment? Isn't it obvious that this case needed a psychological expert? Isn't it also obvious that the psychological expert was going to have to visit the children and any parents that were prepared to engage? In other words, you're not complaining, are you, that Mr. Flatman spoke to your client?
No.
So what if he's going to be doing that, what's he doing that for? If not to better understand the world of the children?
I can accept that in order to understand the children, he would inevitably have to meet with the parents in order to answer the questions that he was asked to consider. But he wasn't just asked to consider what the issues were in relation to the children. He was also asked to consider, obviously, the psychological profile of the mother and the father. And I would argue respectfully that whether or not he was experienced, whether he had 40 years of experience, even in the tribunal decision, that length of experience did not qualify him to act and provide a clinical assessment. And that is where the problem, we say, still arises in this case, because essentially he did go on to provide a full psychological assessment of the mother, and the judge did rely on
You want to take us to the parts of the report in relation to the assessment of the mother that you view as being particularly objectionable?
allow me one moment, my lord. I'm just trying to.
I think we have it, in my copy it's at 170. So
Yes,
adjacent.
170. Page 63 of 88.
Forgive me, my lord. What was the reference that you referred to?
It's in the core bundle at page 170
Yes.
or thereabout, 169.
Yes, yes.
And there's a lot of narrative gained from the papers and from interview. Would you accept that whatever Mr. Flatman's limits of qualification, that was perfectly appropriate for him to include in his report?
Yes, I don't suggest that that was improper. The difficulty arises in how he analyses that information in accordance with the testing and in accordance with the...
Right. So where do you say he does that?
The reference to the testing only really comes in at paragraph 834.
Yes. At PDF 174.
But a number of stages he refers to her lack of insight and strong tendency to prioritise her own relationship needs above the children. That isn't necessarily a psychological evaluation, it's an observation. Or lack of insight. Paragraph 855, the attachment with the elder child is marked by insecurity, will my needs be met, anxiety, my attachment always seems to be conditional, and ambivalent. That's attachment.
So at page 174, at 8.34, this is a paragraph that I've taken the Lordship's to before, that he indicates that the mother produces an invalid disclosure on the MCMI-3.
Yes.
And he indicates,
34.
yes,
Yeah.
and that it probably indicates her tendency for minimising and avoiding. And so paragraph 8.35 has to be considered in view of the preceding paragraph. Therein lies part of the difficulty of how Mr. Flatman has produced his report, because his assessments, which we say he was not permitted to undertake, lead him to a certain view.
Could we go back to the passage my Lord's just referred to, which is 855 at 178? 854 through to 856. Is there anything improper about the assessment of attachment with children?
That feeds into, of course, looking at the remit.
Sorry, I didn't catch that.
Sorry. Insofar as the attachment is marked by insecurity and anxiety and an ambivalent query and ambivalent attachment, these things tie into what we say is the clear remit of a clinical psychologist, which is the BPS guidance at page 171, which is to look at personality difficulties.
Internal page?
Internal page 22. .
Why doesn't it come under internal page 23? The first paragraph under B.
Because, as the paragraph says, they are qualified to address concerns affecting psychological and emotional development and learning, expressed by and on behalf of infants, children and young people.
Well, if you have an insecure, ambivalent, whatever else attachment, isn't that core territory?
On the detail of that, page 23, 172, it's the fourth bullet point. It says, educational psychologists need to be able to understand theories and evidence underlying psychological intervention with children and adolescents, their parents, stroke carers, education. And so doesn't that include attachment to their parents?
If we look, yes, it does, but if we look at paragraph 8.56, it's clear that Mr. Flatman is commenting on the mother's attachment as being insecure and anxious. It is, as question 15 says, please assess the mother's attachment with her children.
What is the status that you attribute to the BPS guidance?
My Lord, I'm sorry, I didn't hear.
What is the status that you attribute to the BPS guidance? There's quite a lot in the guidance about regulation and who the court can appoint. It's all in section 3, internal pages 8 and 9.
The BPS guidance obviously makes it clear that experts have to engage in their professional codes of conduct and ethical frameworks.
Well, that's their regulatory framework.
And we say that it is the responsibility of the psychological expert to be transparent in relation to their qualifications and registration, to assist the court in determining their suitability for a necessary expert opinion. And so we say that the BPS guidance is important insofar as the understanding of how experts are to be instructed is concerned.
Yes, but what is the status of that? I mean, the guidance recognises at paragraph 3.10 on page 9 that the court can appoint individuals who aren't eligible for membership of the BPS or registered with the HCPC. So it's not trying to limit the power of the court. You then go on to say, well, the expert must be transparent, but if the expert genuinely thinks that he is qualified to make an assessment of one kind or another, which goes outside his professional regulation, what is untransparent or opaque about that?
Well, at page 159, paragraph 4.2, HCPC registered psychologists are obliged.
4.2, yeah?
Yes. the psychologists registered with the HCPC are obliged to meet its standards of performance and ethics. And it lists A to E. So to act in the best interests of service users, and which we say is applicable here. D, to act within the limits of their knowledge, skills and experience, and if necessary, refer the matter to another practitioner, which we say was relevant here. And E, to behave with honesty and integrity and make sure that their behaviour does not damage the public's confidence in the practitioner or their profession.
So are you saying then that a failure to comply with a regulatory code of conduct disqualifies the person who is failing to comply from giving expert evidence?
If they are not qualified to do so.
No, that's not the question I asked you. If they have failed to comply with the code of conduct of the HCPC, are they debarred from giving expert evidence outside the ambit of their protected title as a matter of law?
As a matter of law, as it stands, the answer is no. And that's the difficulty with an appeal of this nature, is because we don't have anything that subscribes psychologists of whatever discipline. That is precisely why we find ourselves in this appeal, my lord.
So paragraph 52 of your skeleton argument, sorry to be dotting around. Paragraph 52. The top of the page. The issue is not how Mr. Flatman described himself, but whether he was lawfully competent to undertake the tasks he was instructed to perform. So what's the basis of, this is your key assertion, there's only 2 paragraphs in the whole skeleton about Mr. Flatman's status, and this is your key assertion that he was not lawfully competent to undertake the task. So what's the basis of that key submission?
I think, my lord, I have to be fair in saying that we can't go so far as to say he's not lawfully competent.
No.
I'm sorry.
That, forgive me, my lord, I don't think it would be fair for us to say that he was not lawfully competent.
You say we can't go so far.
See, we've all been guilty in the family court, I'm sure, of not looking as closely at this as we have in recent years. But during my experience, and I'm sure also my Lord the President's, we would frequently engage with people who were calling themselves child psychologists. The family court would rely particularly on people who were psychologists, who had a special interest in the predicaments of children. Now, actually, when one looks, as I've just done, at the BPS guidance, it mentions 8 sorts of psychologists as being protected titles, none of which is child psychologist. I'm just trying to think of how the family court is to deal with the sort of argument that we've got here, where there's obviously considerable overlap between specialist disciplines. And if your submission is that had this surfaced before Mr. Flatman was appointed, he wouldn't have been appointed because he's deficient in some important respect. But at the same time, the court wanted an overview psychologically of the whole family. Where were they to go? Where were they to go? What sort of a psychologist should there have been instead of this very experienced educational psychologist?
We say a very experienced clinical psychologist.
Right, so your position then is that, because this is no disrespect to the individuals involved,
Yes.
a quite standard set of facts for a family court to confront in care proceedings, we can forget about educational psychologists. We can forget about all sorts of other psychologists, because the only person that can advise is a clinical psychologist.
No, I'm saying that in this particular case.
Yes, but this case is not by any manner of means unique. Indeed, it's very difficult to think of a case on your analysis where there would be care proceedings, where an educational psychologist would ever be appropriate. They just appear in tribunals and special educational needs issues. Doesn't that show that one has to accept a certain amount of give and take in order to make sure that the family court has the advice it needs from a variety of sources? In a particular case, and I appreciate that nobody thought about this issue until Mr. Flatman's disciplinary issue. It would, for example, had counsel for one of the parents thought, well, Mr. Flatman appears to be pushing it a bit. Mr. Flatman was there to be cross-examined. For example, question Mr. Flatman, you don't have the right to conduct a William test. Answer, yes, I do, or no, I don't. And so the forensic process goes ahead with the judge being alerted to it. I understand here what the reasons were for the judge not being alerted. But aren't there safety nets in the form of the adversarial process to make sure that experts don't act outside their expertise?
I suppose that the difficulty is that, and of course, it isn't simply a case of one size fits all. I accept that. But if the court is presented with a case that involves parents who are engaged in domestic abuse or harm of a child, or there has been adverse child experiences in respect of a parent, however experienced an educational psychologist may be, it is difficult to see how an educational psychologist could address those issues of the adult in those circumstances. I accept that they may be qualified to, and that they are qualified to undertake assessments of children. But one of the fundamental questions that a court has to grapple with when a psychologist is instructed is what the current and future risk is of a particular parent, and therefore what the individual psychoses may reveal. And so that is the difficulty in being able to say, well, an educational psychologist who may have many years of experience, may have given a number of reports, provided a number of reports to the court, will fit the bill.
Could I pick up my Lord's question about the trial process. We have here a report by somebody claiming to be an expert, which is adverse to the mother. The mother wishes to challenge the report, keep her children. The expert says he's registered with the HPCP, whatever the initials are. Surely it would have been open to the mother's legal team to check the registration and to see for what was he registered. And had they done that, they would have found out that he was registered as an educational psychologist. And that could then have been put to him.
It certainly highlights, my lord, the obligations upon court advocates, but the problem arises when somebody accepts on face value what an expert says that they are, and that expert is then instructed. Would it, and I don't mean to pose this as a question to your lordship, but would it automatically generate an advocate to think that at the point of cross-examination they ought to check whether somebody was HCPC registered because their CV is there to be read and is accepted at face value? This case certainly brings up a number of issues, a number of gaps, whether that be with the court not having a formal PD25 application, or what was known by which legal representatives. And even when one looks at that email, it's not entirely clear, even on what Mr. Flatman says, as to what the issue regarding his qualifications were, because if you read that email, he makes it clear that there's
you're
an issue.
laying considerable stress, and almost the entirety of your stress, on the fact that his registration was as an educational psychologist. I mean, he says he has lots of experience outside that field, but you're concentrating on the fact of his registration. Now, that would have been easily discoverable by somebody preparing to cross-examine him with a view to challenging his opinion.
Again, I can only comment. Of course, we were not
I think
the mother's.
certainly with hindsight, my lord's observation's obviously right. My understanding, although I've got, I think, no recollection of Mr. Flatman, is that he was widely used across the family court, and it's a bit like the King's New Clothes. He was taken as being someone who was qualified to do what he was doing on a fairly widespread scale. And
Yes.
so, whilst it may be entirely right to make the observation my lord's just made, which it obviously is right, it may be a counsel of perfection to say that that's what an advocate would do in the lead up to a hearing such as this.
Yes. Yes. I would respectfully agree. And one only has to look at the judgment and how Her Honour Judge Gillespie refers to Mr. Flatman in the judgment, in the recital. He's referred to.
Well,
as
are
a
we going to,
psychologist.
I'm conscious, again in your skeleton, you don't go to the judgment, and don't you have to, in order to make the appeal good, to demonstrate that the judge's decision was contaminated to a significant degree by Mr. Flatman's intervention, to the extent that the whole process that she conducted was, you say, in breach of Article 6?
Yes.
And if you were going to do that later in your submissions, then I'm happy to wait for that. But I think at some stage we do need to do that. Well, it obviously starts at page 85 of the printed Bible. This was a 5-day hearing
my lords will see that at page 89, the judge refers to Mr. Flatman, and essentially she sets out somewhat extensively
Yes.
Mr. Flatman's opinions, and she says so at page 91, paragraph 24, that she sets it out in that much detail as it was an extremely thorough and extensive assessment.
Yes. It's all evidence, measured, helpful. I fully accept the professional views in respect of the mother and the children.
And whilst I accept that the judgment is also concerned with four contested findings, a number of findings before that had already been conceded, and there were four contested findings, two of which were conceded in evidence, one which concerned home conditions that the court then went on to make findings on, and then one which is paragraph 6 of the findings that relates to the assessment of risk.
But
But
before we move on, looking at paragraph, I think it's paragraph 25, but after the extensive quote from Mr. Flatman, she says, as we've just rehearsed, I set out Mr. Flatman's opinion in detail. Then, moving on, he didn't deviate. He accepted entirely that she loves the children, hasn't set out deliberately to cause them harm. He stayed very sad that the mother makes completely heartfelt and reasonable statements regarding her love for the children, but that is not what the children are experiencing. So this is her summary, as I read it, of the essential take that she had from Mr. Flatman's evidence. And she said that that is fundamental and crucial, and the children's day-to-day experiences are not those of unquestioning love and care. Mr. Flatman didn't feel there had been any insight from the mother, and that she was essentially in denial and presents her version of the truth. The difficulty for the mother is that, on an unconscious level, she cannot bear to accept the implication that her conduct and behaviour have been a major contribution to the children's difficulties. All of the children now needed better than good enough care, than required better than good enough carer. So that, to my eyes, and correct me if I'm taking an erroneous view, is the judge's summary of what Mr. Flatman was saying to her, and it'll be clear, because we've all read the judgment, that essentially the lack of insight and the inability to accept that she was in any way causative any difficulties for the children was replicated by the independent social worker, the social worker, and crucially from the judge's own appraisal of the mother, who will have given extensive oral evidence before the judge, and the judge said she found the mother's evidence very troubling. So if that's the take from Mr. Flatman, it wasn't really a psychological assessment, it was his understanding that she just didn't get it. She didn't have any insight into what was going on around her in emotional terms, in terms of attachment. And in terms of the judge's decision, what he said was congruent, or whatever the word would be, with the other evidence, but it wasn't determinative. It didn't turn the trial, because the judge, crucially, the judge formed her own view of the mother, seeing her in the witness box, and it's that view, I would have thought, was the predominant driver for the judge's conclusion.
We respectfully submit that whilst the judge had evidence available to her in relation to the mother's parenting and the contested matters of the findings that were put before her to be determined, the other part of the other side of the coin that Her Honour Judge Gillespie had to grapple with was whether or not the extent of the mother's insight meant that the children could be placed in her care safely within the children's timescales.
It goes back to the timescale.
And so, whilst I accept that Her Honour Judge Gillespie had, of course, available to her all of the social work evidence and the evidence of the parents, and found against the mother, and that is clear in the judgment. The fact is that we say that the judge also relied upon Mr. Flatman's evidence insofar as the mother's inability to seek to change, and that the children therefore needed better than good enough parenting.
Right.
And so at paragraph 59, we see, it's at page 100, we see that she fully accepts the evidence about the children, that they need better than good enough care. And it may be said, my lords, that, well, Mr. Flatman was entitled to, or the court was entitled to rely upon that because that was within his expertise as an educational psychologist. But it also says that childhood experiences caused by direct harm and the risk of harm as a result of the behaviour of their mother. And that's about the risk of harm, because that is also central as to whether or not the children could be returned to their mother.
But hasn't the judge made findings about that between paragraphs 38 and 41? And in particular on 38, she sets out her general impression of the mother, minimising evasive, deflective, drip feed information, and so forth. 41, she didn't accept at all that she'd caused that particular child any emotional harm or turmoil. 39, everyone was lying or exaggerating. Now that's all the judge's impression of the mother's own evidence.
I accept that, but I go back to the question of necessity. This court felt that it was necessary to instruct the psychologist to assist the court in relation to the longer term plans for the children. And so whilst I accept that the mother was found wanting in her evidence, and it's clear that the court found that, we can't simply extricate the psychological element of the case. We say because it is clear that that psychological assessment was necessary, it was needed to look at whether or not the children could be returned to the mother in the timescales. And it is clear from Mr. Flatman's assessment that having conducted the psychological assessment of the mother, it was not a positive assessment. And that was clearly taken into account by the learned judge. It's also right to say that Mr. Flatman's assessment of the mother and the children were relied upon within the care plans for the children, and your lordships will see that in the care planning documents. There is extensive reliance on what Mr. Flatman says. And so we say it is difficult to divorce the judge's decision making simply on the basis of the other evidence that the court heard and parents. And I suppose that that leads me on to the other aspect of this case, which is the instruction of Dr. Solomon's.
Now, if I've understood that Dr. Solomons was instructed after the case, the hearing before the judge finished.
It was, yes, he was instructed during the life of the care order.
Right, so why are we concerned with Dr. Solomons?
Well, we know from the position statement, the original position statement of the respondent, that part of the argument as to why the appeal should not be allowed is because the local authority commissioned a further psychological assessment outside of proceedings, and therefore it was simply to respond to that, argument.
Well, I'm speaking for myself. Having granted permission for that to be filed, that was solely in order that we should try and gather in as much of the limited information as was available. Further speaking for myself, I don't consider that Dr. Solomons has got anything to do with this appeal at all.
No.
It may have been a very sensible thing for the local authority to have done, in the circumstances it was faced in order to do a sense check on where the children were. But I can't for the moment see that it's got anything to do with the appeal. And so to that extent, I rather agree with what you said.
We take it in stages, Mr. Madison. You say there has been a serious procedural irregularity which has caused injustice. As a result of that, you say that the trial before the judge was unjust. You didn't get a fair trial.
Yes.
Well, if that's made out, then the whole thing has to be set aside. We would have to start again. You can't salvage bits of an unfair trial.
I suppose, and this is what we have addressed in our skeleton argument, is that the factual findings, which were essentially 6 in total, we don't challenge. We accept that the court was entitled to make those findings. They are factual issues. This appeal rests on the procedural issue, as your lordship indicates. That is why we suggest that in looking at this particular appeal, what the mother seeks is only a narrow hearing that focuses on the risk element, the psychological risk, with an expert who can be appropriately challenged on the basis that they are a clinical psychologist having provided a clinical psychological assessment. We say that that position is not destabilising, it's the least disruptive course that's consistent with fairness, but it would be a limited, focused rehearing that is simply narrowed to current and future risk. I know that in my skeleton argument I referred to the fact that the children are now 15 and the two boys are 8, and that already, notwithstanding the care plan that recommended a minimum of twice per year contact, that the mother is in fact having more contact, and in fact in certain instances her contact is not supervised by the local authority in respect of Evie, the 15-year-old. And whilst I accept that none of that is relevant to whether an appeal should be allowed, what it does focus the appellant's mind to is how important it is to have a risk assessment that is carried out by a clinical psychologist who has had access to the mother's medical records, who has had access to...
But it may well be that the time has come or is coming when your client would apply to discharge the care order or increase the contact so that she's seeing even more of the children. And it may be that within that process a fresh assessment is undertaken. But those are not matters for appeal.
No.
If life has moved on, as you say, then that might well be the right way forward.
Yes.
Ms. Madison, would you tell us what your submission is about this? That we're here on an appeal in order to try and not only consider your client's situation and the children's situation in the light of the ground of appeal, but also in order to consider in general what the correct approach is where there is a challenge to an expert's credentials, which have been acted upon, in this case, some time ago.
Yes.
Now, various options are set out at the ends of your respective skeleton arguments. If we were to move away from this case and just think of other people who may be aware of Mr. Flatman's disciplinary proceedings, the fact that an appeal is being heard here today, who had Mr. Flatman in their cases, it is the best course for them to appeal, or is it not rather for them to lie under the family procedure rules for a reconsideration, for further evidence to be called, maybe to apply to discharge the care order in an appropriate case, or to apply for more contact in an appropriate case, as my Lord has said might apply here? Should the first port of call be the family court or the Court of Appeal?
Yes, in many ways, my lord, this case brings up those issues, and in fairness, the issues relating to this case and the appellate procedure, we say, was brought about because of the unusual procedural history. We don't say that the Court of Appeal should be the automatic avenue for cases of this nature, because we are anxious to avoid a floodgates approach, and potentially it would not be right for the Court of Appeal to essentially look at issues when potentially a trial judge who dealt with the case may be better informed.
Well, and also, even if it wasn't possible to be the trial judge for one reason or another, the family court has the opportunity to get to grips with the actual evidence as it stands,
Yes,
which this court doesn't.
yes.
I mean, I wouldn't rule out that there might be some circumstances in which an appeal might, for some reason or other, be the right answer. But in general, would it not be best if this court signposted anybody who wished to make an issue like this, take it before a court, to take it before the family court?
Yes.
And then you may know, my lords may know, that Mrs. Justice Judd heard a case where another expert who's in a different category from Mr. Flatman, an expert who's not registered at all with the HCPC, Melanie Gill, Mrs. Justice Judd, who named Melanie Gill in the judgment, heard that as an application to reopen the factual findings under Part 18 of the Family Procedure Rules. And I heard a similar application also involving Melanie Gill, again under Part 18. And that seems to me to give the court a much more flexible and wider range of options. And in particular, the court has to look at, under the 3 stages of evaluation, which in fact Lord Justice Peter Jackson has helped in clarifying in a number of cases, look to see whether there's solid ground that a different factual conclusion would be likely to be reached. And that's partly what we've been involved in today, but the appeal is quite a blunt instrument. Either you succeed
Yes.
in what seems to me to be quite a high hurdle of showing that the flaw in Mr. Flatman's instruction and his delivery of his response to those instructions was such to be a procedural error. It either was, in which case, as my Lord says, the whole thing goes and there has to be a rehearing, or there wasn't and the appeal fails, whereas the family court can look at it in a more nuanced way and in particular take account of the fresh evidence of how your client has been doing and how the children have been doing in recent times, and just decide whether there's a need to reopen these matters. I see you nodding, so
Yes.
that's landed well.
Yes, yes.
Yeah.
Yes, I
Yeah.
see that, yes.
Good. So, Ms. Madison, we've probably taken you completely out of the course that you had in your mind when you walked through the door of the court some time ago. Are there other submissions that you want to make? Maybe you want to talk to Ms. Cook or hand us to check.
Yes, if that's possible, my lord.
Nothing else you want? Nothing. Shall we rise for a minute?
There's nothing further, my lord.
No. Well, I think it would be helpful before we hear from Mr. Davis for me just to take stock with my lords as to where we've got to. So we'll rise for a short time. Only leave the room if you need to. We'll be back very shortly.
Court rise able.
go into probably all proceeding. I'm just saying my timing's terrible, but I'm kind of keeping up. But is it a nice thing? The local authority.
Yeah.
Right. And that was, but the neighbours were not interested.
Yes, absolutely. Yeah.
Um, Okay, couldn't wait. Time that's it. We finished with Brett by one. I'll leave it that. So when in the life
report writing able?
Yes, Mr. Davis. It is plain that the case for the appellant has been reduced by some of the submissions that Ms. Madison has made and some of the concessions made. But we do want to hear from you about the basic elements of the appeal, and in particular some of the points that we've raised.
Of course, my lord. So I deal first with procedural unfairness. And it's the local authority's submission that there hasn't been procedural unfairness. The local authority would concede that when things are viewed from the mother's perspective, to see the report from the HCPC disciplining Mr. Flatman, there would be perceived unfairness. But that is different to procedural unfairness. In this matter, the application for an expert, as my Lord, Lord Justice Peter Jackson has indicated, could have been made with more rigour. But it was nonetheless an application made fairly at court, where all of the lawyers present knew of Mr. Flatman. There was a CV which differs from the CV set out in the report prepared by Mr. Flatman on file, on the local authority's file at the time, which also makes clear that he was in fact an educational psychologist.
Do we have that?
My Lord, you don't, but that can be made available if
Well, I
that
think
would
if you're
assist.
relying on that, we need to have that.
But that also makes clear that Mr. Flatman was a chartered psychologist. Pausing here, can I acknowledge and concede that the email at page 60 of the supplementary bundle, where Mr. Flatman warns of his investigation by the HCPC, does not appear to have been shared in writing with the mother's team. The authority have no email showing that email being forwarded on to Mother's Council
And
or
you
Mother's
presumably
solicitors.
accept that they, you stress in writing, but in one way or another, the mother's team should have been expressly told.
My Lord, of
about
course.
that.
Of course. And I can't say that they were or they weren't.
No.
And there may well have been discussions at court. So I don't know, I wasn't there. But I can't gainsay the mother's team's view that that particular information wasn't shared.
And
Well, I'm sorry. I was left with the impression that nobody really knows.
I think that's the answer, my Lord, yes.
It may very well be, and I doubt it for a moment, that the mother herself would say that I never knew this at the beginning, but I don't know that we know what her lawyers knew.
My Lord, that's the situation. And all I can say is that the correspondence file has been checked.
but thinking about it, if you, Mr. Davis, were counsel for the mother at the hearing, you received the report from Mr. Flatman, it's adverse to your client, and you knew that he was the subject of disciplinary proceedings at the age, you would be asking some questions about that because you'd be looking for material to cross-examine. So my hunch, it's not going to take us very far one way or the other in the appeal, but my hunch is that the mother's team didn't know, but we can't say that.
My Lord, yes, I think that's fair.
But you can't trace the email correspondence around that time in your legal department.
Well, you can, and it's not there.
We looked at the email correspondence around that time, and there is no email setting out the warning of Mr. Flatman to the mother's team in
I
writing.
understand that. Is there an email telling people that Mr. Flatman is available, and can we please unite and appoint?
But there's nothing more than the email at pages 60 and 61 in the court bundle.
Are the mother's lawyers copied into that?
No, they're not.
Right. Well, but I mean, Mr. Flatman obviously didn't just descend from a cloud in order to start his interviews. Somebody must have told somebody that this was the timetable that was being proposed, and indeed get agreement to that.
My Lord, yes. Yes, no doubt there were discussions at court on the day of the hearing when the permission was granted.
Is the sequence of events: parties attended court, psychologist approved in principle, inquiries made that we've seen psychologist identified, order drawn up with psychologist's name inserted?
Well, I can't say whether there was widespread agreement at the time from the lawyers as to the instruction of Mr. Flatman, but I can say the inquiries were made and then the order was drawn up in that order.
Yes, because Mr. Flatman's name appears in the order.
My lord, yes.
So I'm presuming that the order was signed off by all parties before the judge actually had it sealed.
My lord, before it was submitted for the judge's approval, yes.
Yes, right. So that's the sequence of events, I understand.
Yeah.
Certainly. Since the authority's submission, there hasn't been procedural unfairness and the process of instructing Mr. Flatman was proper. There was an opportunity for cross-examination about the scope of Mr. Flatman's expertise at the final hearing. The authority, in its narrative statement at the permission to appeal stage, at paragraph 7, made the point that the decision in this court in Ray say parental alienation, which dealt with the need to focus on.
I don't think it was this court. I was sitting in the High Court.
My lord, you're quite right. It was my lord's judgment. Was available, so those issues were fresh in counsel's minds at the time.
Well, this judgment is 2023. So I'm just querying whether my judgment was. So the hearing, March 23. And we see is.
It was 21st of February 2023, so it's
Right,
weeks
there we are.
before.
Hot off the press. Then. Yes.
And my lord,
But the order for Mr. Flatman was a year earlier, when this issue had not surfaced to, as it were, professional consciousness to the same degree as it has now. So it was a hot topic by the time of the trial, but not at the time of the appointment, by which time Mr. Flatman had long since provided his report.
my lord, yes, I accept that. However, there was room for cross-examination.
Your point is that by the time the cross-examination took place, insofar as people would have known of my judgment, it was a known and could have been used. We don't know whether it was, or not. There's no record of it being used.
My lord, accept that.
Can I just go back a stage, Mr. Davis? You said that I think there might be perceived unfairness, but not procedural unfairness. The criterion which we are asked to apply under Part 52, Rule 21, is that we would allow an appeal where the decision of the lower court was unjust because of a serious procedural or other irregularity in the proceedings. So the decision itself must be unjust, and there must be an irregularity, which may be procedural, but may be something else.
My lord, yes. And addressing that particular point, the authority's primary case is Mr. Flatman was instructed as a chartered psychologist. He held himself out at all times to be a chartered psychologist. The CV, which my lords haven't seen yet, but will follow in due course, describes him as a chartered psychologist. He is in fact registered with the British Psychological Society as a chartered psychologist. The relevance of the tribunal decision, the Health and Care Professionals Tribunal decision that's before the court, was proceeding on the basis that in that case, Mr. Flatman held himself out as a clinical psychologist. So from the start, the factual matrix in this case is significantly different.
When you say held himself out, he'd allowed himself to be described as. That he hadn't said he was a clinical psychologist, said he was described as a clinical psychologist, and he made no effort to disabuse people. Was that not the... I may be wrong.
I think he, from memory, and I can check, I think on the report he'd used the protected title consultant psychiatrist in the case that was before the Health and Care Professionals Tribunal.
Okay,
Well, we can.
So in making the submission stressing that he's a chartered psychologist, are you implying that that gave him a professional ambit which was wider than simply an educational psychologist and would include assessing adults such as the mother in this case?
My Lord, yes, that's exactly the submission the authority make. And it has relevance in a number of aspects to the instructions which Mr. Flatman received. Before I move on to address that, there are two...
Just before we move on, picking up my Lord Justice Peter Jackson's question, the findings of the panel, at paragraph 121, page 33 of the supplemental bundle, the panel noted the registrant, that is Mr. Flatman, did not attribute the protected title of clinical psychologist to himself.
That's what I thought.
He was so described in the order appointing him, and the complaint was that he undertook those instructions without telling anybody that he wasn't a clinical psychologist. But the finding of the tribunal is that he didn't attribute the title to himself in his reports.
Yeah, that's right.
Very well, my Lord, I accept that. I'm grateful for the clarification. In terms of Mr. Flatman's role in this case as a chartered psychologist, first of all, my learned friend has made the point that the guidance from the British Psychological Society and the Family Justice Council for psychologists as experts in family proceedings does make the point that where an expert has a protected title, they should ordinarily use that title. And although the guidance that's been filed with the court is dated in 2023, the earlier guidance from January 2016 also had that requirement that if you have a protected title, it should be used. The status of the guidance is just guidance. It is not issued by the British Psychological Society pursuant to any legislation or regulations. Only the healthcare and professionals at the HCPC, only the HCPC has the authority to issue guidance which carries more effect than just being guidance, pursuant to the Health Professionals Order 2001. So the status of that guidance is just guidance. In my submission, that connotes the impression that it's there to be followed unless there are good reasons not to do so.
So, Mr. Flatman, whether before or after 2013, was entitled to describe himself as either a chartered psychologist or an educational psychologist. Is that where we get to?
So, my Lord, I think, strictly speaking, the guidance would say that if there is a protected title, of which chartered psychologist is not one of the protected titles, then Mr. Flatman should ordinarily use the title educational psychologist. However, the guidance doesn't go on to deal with the situation, whereas here, in circumstances where Mr. Flatman was instructed as a chartered psychologist, it does not make clear whether in those circumstances it is permissible for Mr. Flatman to simply describe himself as a chartered psychologist.
Chartered psychologist is not a protected title. It's simply something that it has to be true. You have to be chartered. The protected titles would be educational psychologists.
So chartered psychologist is something more than the use of, for example, child psychologist. It is a title that requires registration with the British...
If we look at in the guidance paragraphs 5.1, 5.2 and 5.3, which I've got at...
Sorry, my Lord,
5.1, 5.2, 5.3...
Of the guidance.
The guidance,
Thank
at
you.
page 161 of the printed supplemental bundle. 161. Practitioner psychologists must maintain current HCPC registration to undertake practice. Academic psychologists should be chartered members of the BPS on the basis of their research expertise in a specific area of psychology within which they are offering an opinion. Only HCPC registered psychologists have the relevant clinical experience and training to conduct psychological assessments of people and make clinical diagnoses and recommendations for treatment or intervention, whereas academic psychologists, who should be chartered but who are not registered with the HCPC, would not normally have the clinical experience and training in order to complete psychological assessments and make clinical diagnoses. So the distinction is between an academic who doesn't see patients and isn't qualified to give assessments and someone who's registered. So isn't the relevant category for Mr. Flatman his registration as an educational psychologist in terms of his ability or standing to give an assessment of people in court proceedings?
My Lord, yes, I think the answer is maybe.
Right.
And I say that because of the use of the words in the paragraph my Lord refers to, the third line, but who are not registered with the HCPC would not normally have the clinical experience and training in order to complete psychological assessments and make clinical diagnoses.
Yes.
And I say that in the context of what the HCP tribunal did find. And paragraph 173 of the judgment of the tribunal which is at page 34 in the supplementary bundle. The tribunal acknowledged that Mr.
Which
Flatman,
paragraph?
at paragraph 173, it's the bottom of internal page 34,
Technically qualified to assess.
technically qualified to undertake psychometric testing. And earlier in the tribunal's judgment, there is discussion about particular training which Mr. Flatman had undertaken, which didn't assist Mr. Flatman in the particular case before the tribunal, because that training had been undertaken after the psychometric testing in that particular case. But it stands to reason, given the date of the HCP tribunal's decision, that Mr. Flatman had done the training in respect of psychometric testing before he undertook the assessments in this case. And it's not clear whether, as a chartered psychologist, Mr. Flatman would be able to undertake psychometric testing. The guidance is, as my Lord has identified, that a chartered psychologist would not normally do that testing. But that must...
I couldn't find the reference, but didn't they, in the disciplinary proceedings for Mr. Flatman, didn't the panel hold that despite the fact he was chartered, he wasn't entitled to act in the way that he had done in those proceedings?
My Lord, it did.
But conducting those tests.
It did, my Lord, that's right. But there were two principal reasons for that. The first was in the context of him not being a clinical psychologist, i.e. being an educational psychologist. Yeah. And second, that the training that Mr. Flatman had undertaken in respect to the psychometric testing took place after he'd assessed the parents in the particular case before the tribunal. And they didn't go on to, in my submission, they didn't go on to express a view about it.
A very basic question, but is registered and chartered, are they interchangeable words?
No.
I'm sorry.
No, right.
I'm sorry, my Lord, I didn't hear the question.
No, sorry, I've asked a question which says, is registered the same as chartered? How do you become a chartered psychologist? Is it a consequence of registration, or is it a consequence of you being a protected, you having qualified as one of the protected types?
Neither. You can. My understanding,
Yes,
I may be wrong, is that an individual can be a chartered psychologist, full stop, and they will tend to be academics and not have a clinical practice. If you've got a clinical practice, then you would separately need to be registered in one of the protected categories. You can be registered in one of the protected categories without ever being chartered. So some people, like Mr. Flatman, can quite properly be both. But you don't. They are different, and they're not interchangeable. That's my view. happy to be wrong.
That's very better off as
The guidance, I think, does set out the routes to becoming a chartered psychologist. At paragraph 3.3 on page 8 of the guidance, or page 157 in the authorities bundle. My Lord, I accept that at points the guidance does draw the distinction between practitioner psychologists who should be registered with the HCPC and academic psychologists who are chartered, who may be chartered members registered with the BCP. So I accept that definition is there in the guidance.
And pulling this together in relation to this case, is there anything that Mr. Flatman did that you concede was outside his competence in relation to the mother in particular?
My Lord, the issue of whether or not Mr. Flatman was qualified to undertake psychometric testing is likely to be a question of fact. The court would need to hear from Mr. Flatman about his particular training and if the matter required determination, it would likely require the sort of procedure adopted in the authority which my learned friend has put before the courts of the decision of Justice Hayden.
Re-F. That's on page 103.
In that case, the expert gave evidence before Mr. Justice Hayden and findings were made. But I don't think it's an issue that this court could determine today whether or not Mr. Flatman was or was not qualified to undertake the psychometric testing.
Well, if we could just use a completely hypothetical example, where you had a parent, let's say a father, who had a long history of severe mental illness, obviously something very wildly unusual about their behaviour. Can one contemplate Mr. Flatman, for example, diagnosing a personality disorder as a result of psychometric testing? Can one contemplate him making a finding of some acute mental disorder?
My Lord, no.
I don't think a psychologist would claim to be qualified to diagnose an acute mental disorder. That would be a psychiatrist, would it?
Yes, it would be, and a personality disorder might fall within the scope of a psychologist.
Yes, exactly.
So stick with the personality disorder.
And I would agree with my Lord that would be a psychiatrist that's required for the reasons that are set out in my Lord's judgment of recent parental alienation. There's a very clear explanation of the guidance about why a psychiatrist would be required for that sort of diagnosis.
But let's suppose the father was diagnosed by the educational psychologist as having a personality disorder that nobody else had picked up. I mean, would that be something one would argue about on the facts, or is it plain that that's not the job of an educational psychologist?
It would fall outside of the regulatory expertise of the educational psychologist.
Certainly I've seen, sorry.
I was going to say that if we look at what Mr. Flatman said in his report, paragraph 3.6.1, he's dealing with the psychometric assessment of personality. Talks a bit about personality disorders, but at the end of the paragraph he says, the diagnosis of personality disorders is a matter for psychiatric experience. So he doesn't seem to be claiming expertise to do that diagnosis. He seems to be saying it's for a psychiatrist.
What certainly I've seen psychologists do is, and I think it's probably got a duty to do, say, in the course of my assessment, I have noted that the following characteristics, which are relevant to the criteria of a diagnosis of this, seem to be present in this case, but I'm not qualified to make the diagnosis. This ought to be considered to be reference on to a psychiatrist. So they flag it up without making the diagnosis themselves.
Well, yes, and I'd say there's nothing objectionable about that. Indeed, it's helpful.
Quite a responsible thing to do.
My Lord, yes. And in response to my Lord Justice Lewison's comments about no diagnosis made by Mr. Flatman in these proceedings, I understand that to be common ground.
Yeah.
But I think my Lord Justice Peter Jackson's question was a generic question, thinking about wider cases.
Yes.
So the authority's submission is that Mr. Flatman held himself out as a chartered psychologist, in respect of which the instructions are likely to have fallen within that remit. Yeah. The order, of course, was silent as to the type of psychologist to be appointed, as was the letter of instruction. In terms of, as this hearing has developed, whether or not matters fall within the expertise of Mr. Flatman as an educational...
A slackness, and I think all in the family court, including me, have probably been guilty of this. On one view, the case that led Mr. Flatman before the disciplinary tribunal, someone put the phrase clinical psychologist in the order, then nobody looked at it again and query. Whoever put it in the order didn't necessarily mean to restrict the instruction to a clinical psychologist. They may have done. Here, no thought was given to categorising the type of psychologist. It is said psychologist. And so either way, there's a slackness. If you're going to go into a realm where people need to be registered with the HCPC, or ought to be registered with the HCPC before they're instructed, then the category of registration probably needs to be clarified. We need to move away from just simply saying psychologist, because that seemingly could apply to anyone in this room could put themselves forward as a psychologist.
My Lord, yes. And of course the British Psychological Society guidance about experts as psychologists and my Lord's judgment in Ray C. parental alienation urge rigour in reviewing the expert that's been appointed and ensuring that checks are made about the regulatory standing and the title used in orders and the like.
Yeah.
And so they're the authorities' submissions about Mr. Flatman's standing to undertake the assessment. We say that Mr. Flatman was entitled to do the assessment as chartered psychologist. I haven't dealt with the issue of whether or not, as an educational psychologist, Mr. Flatman could undertake the assessment. The authority's view is certainly that all of the assessment of the children fall squarely within his remit, including the attachment between the parent and child. In my learned friend's submissions, there's been an attempt to split that into two different tasks and look at that from both the mother's perspective and the children's perspective. But in my submission, that's an artificial approach to assessing attachment between a mother and child. Any proper assessment of attachment theory is a two-way analysis. Attachment is about how the child perceives its mother as a caregiver, about the availability of carers being there, about the mother being able to keep the child safe. And on the basis of how that attachment is, the child's presentation is assessed. So it's, in my submission, part and parcel of the same thing, and it can't be split down, and it falls squarely within the bread and butter of educational psychology assessments. The issue of psychometric testing of adults is likely to fall outside of the expertise of an educational psychologist for the reasons outlined in the British Psychological Society guidance, to which my learned friend took the court to earlier. However, the psychological assessment was part of the bigger picture of evidence before the trial judge. And I've set out extensively in the skeleton argument that first of all, the trial judge was entitled to make the findings that she made in respect of threshold based on the oral evidence she heard, particularly from the mother, the grandmother, and the father of the twins. But she also made findings about the extent of the children's needs and the likely care that the children needed to be afforded moving forward. And these were care proceedings that had gone on for over a year. The judge was entitled to make findings about the mother's insight into concerns professionals held in respect of her ability to protect the children from risks posed by the twins' father. That issue can't be divorced from the likely timescales for the mother making change. The judge, on the basis of the findings she made, was also entitled to find that the mother was unlikely to make changes, the necessary changes, within the children's timescales.
Indeed, the Christmas episode when Mr. M was introduced into the household happened only three months before the hearing. So that if
it was 2021, my lord.
The previous Christmas.
My lord, yes,
Right,
it was
okay,
December
that's wrong.
2021.
Yeah.
So it was
You're quite
15 months before.
You're quite right.
But shortly before the final hearing, Mr. M had resumed living with the mother. At that stage, and the judge made comments in that respect.
Yes, so in terms of the mother's insight and her ability to change, that was a retrogressive indication.
My lord, yes. The judge described how the mother was protective of Mr. M in her oral evidence. She was entitled to make the finding that there was a lack of insight there. And as I say, the authority submits that is inherently linked to whether change could be made in the children's timescales.
Yeah.
I think, my lord, they are the submissions.
Yes.
I don't think the court requires me to address Mr. Solomon's report.
No, and where are you? I think we know because you deal with it in your skeleton on the correct route for parties who find themselves in this position. Should it be an appeal or should it be back to the first instance court with either an application to reopen the fact-finding or a discharge or a contact application?
My lord, the authority nailed its colours to the mast
Indeed.
at the permission to appeal stage as to the proper approach, and that is one of two applications, either to apply to reopen the findings if it's submitted that the findings were vulnerable by reliance on the particular expert, the impugned expert, or if, as here, the position is that it's accepted that the court could make the findings that were made, and the proper application, in my submission, would be an application to discharge the care order. And in the skeleton arguments, the authority identifies the most significant benefit of that approach, being that the trial judge, who made the decision way back when, could be appraised of the matter.
Yes, so that's not, as my lord said, that's not always an option. They may have retired, but plainly there's an advantage if that can be achieved.
My lord, yes.
And I think the local authority categorised the appeal route being used in this case as being an abusive process. I'm not sure I'd go that far.
My lord, I accept that. But my lord, the likely scenario where an appeal is appropriate is if an adoption order had been made.
If and what?
if the final care plan had been one of adoption
Adoption.
and the child had been adopted. There are more difficulties there in terms of a route to vary or set aside that order. And there are.
I think that was the case in the Webster and Norfolk.
Exactly right.
Webster and Norfolk, wasn't it?
Yes.
My Lord, yes. And I think the ratio was that there isn't an inherent jurisdiction to set aside an adoption order that's been made, and there's finality there.
Well, you're going to have to
Wait for the
have to
Supreme
wait
Court.
and see. Yes, the Supreme Court says about that.
So adoption will be a special category.
Yes.
In almost all other orders that the family court makes, there is a means to apply to have the order varied or discharged or reconsidered.
Yes.
So that's the authority's submission. And my Lord, we won't categorise an abusive process on appeal. But,
No, I'm sure that's a concession that's well received on the other side. So those are your submissions in...
My Lord, yes. Would my Lord's mind my back just to...
No, not at all. Nothing else from you.
Well, I know nothing further on behalf of the authority unless I can assist my Lords.
No, very grateful to you. And you'll let us have a copy of the CV that you referred to.
My Lord, yes.
And the emails that we've been given are the sum total of what could be retrieved, are they, in relation to the instruction?
My Lord, would you mind my back?
I think we should see everything.
Yeah, absolutely.
My Lord, yes, that's right. What didn't happen was the authority didn't reach out to Miss Ferguson of Council, who represented the mother at the hearing, to ask her whether she had details or had seen that email.
Right, well, I'm not.
No, I think we shouldn't do that.
Right, so I'm not engaged in finger pointing, as it were, but that was something which should have happened but didn't.
It hasn't happened.
Well, there's no note that it has.
She was the counsel for the mother, so it probably wasn't appropriate for the authority to go asking those questions. But those inquiries could be made if they assist the court.
I beg your pardon. I'm very sorry. I was at cross purposes. I can leave matters as they sit. Thank you.
And is there an attendance note of the hearing when the instruction was crystallised?
My Lord, would you mind my back?
Yep.
My Lord, the answer is there will be, but we haven't viewed it.
Well, I think if you can discover something that ought to be disclosed, it needs to go to the other side first, and then if everyone's comfortable, I think it's something we ought to see.
My Lord, of course.
It doesn't. I don't think it alters the appeal, but it's part of the background. Yes, Ms. Madison.
My Lord, it was just on the email point. My instructing solicitor has handed me an email from the solicitor who was representing the mother. And of course this will be disclosed, but in relation to Dr. Flatman, the only emails that she received from him were in relation to arranging the appointment to meet with Ms. Hope, and thereafter the report.
That was after the instruction had been...
Yes, so nothing to do with the investigation.
So mother's representatives, father's representatives, once the decision in principle had been made for a psychologist, took no part at all in the identification of the psychologist and his instruction. They just learnt after the event.
Well, they must have agreed to the identity.
Well, that's what...
The identity must have been agreed, but in terms of the mother's team having knowledge of the investigation, there doesn't appear to have been anything received from Dr. Flatman about the investigation, which of course...
So my question, and I'm sorry if I'm backmarker on this, is whether the mother's team agreed to the appointment of Mr. Flatman before he was in fact instructed, or whether they were presented with a fait accompli after the event.
We would need to make some inquiries.
Sorry?
We would need to make some inquiries about that. I don't
Well,
know.
the order suggests that the representatives, apart from one of the fathers, were at the hearing when the order was made appointing Mr.
Yes, but
Flatman.
there's a time lag between the hearing and the creation of the order, during which time, as I understood it, everybody was finding the psychologist in order that the name could be put in the order. Isn't that what you told us earlier on? That those.
I think that came from the dates on the email.
Yes.
Yes. And
it
so,
came from the
so
dates.
Mr. Flatman was not mentioned at the hearing. It was as a result of the legal effort,
Yes.
which, as I'm understanding at the moment, did not include your client's representatives
Correct.
for some reason that escapes me.
Yes.
That's the picture that we're being given so far, unless the local authority displaces it.
No, I
for its
think
own
that they
files.
agree with that picture, my lord.
Were there any other submissions you wanted
No,
to
they
make in
weren't.
reply?
No, thank you, my lord.
Thank you. Well, we'll obviously reserve our judgments in this appeal. We'll circulate drafts in due course and invite you to identify the inevitable typographical errors, but no more, and we'll hand them down remotely unless either of you identify a need to attend. We're very grateful to you, and very grateful to those behind you who've done all the preparation work. Good, thank you.
All right, thank you.